conditional affidavit.
Yes, what is this?
They have filed a conditional affidavit, my lord.
Yenanta?
This was not their contention earlier, but in paragraph 4, they say, I am in possession of a property adjacent to the decree scheduled property, which is separate, and this, so they give a kata number, etc., etc. This is not their contention anywhere.
No,
My lord, to this
just give that brief facts. I forgot.
my lord, please.
Yes.
My lord, this is a suit for eviction, my lord. OS 64 of 2009. Decreed in my favor. They are asked to vacate the scheduled property.
Yes.
Later on, execution proceedings are initiated. In the meantime, they go for a regular appeal, which is dismissed, and they go for an RSA. In RSA, before this honorable court, they make a submission that we will vacate the property. Give us 3 months' time.
Yes.
Upon that submission, this court disposes of the RSA, but they don't vacate the property, upon which we file a contempt petition. In the contempt petition, they say that we have vacated the property, and they contempt court says make an inquiry if the property has been vacated. If not, take necessary action, put them to civil prison. The execution court conducts an inquiry. By virtue of the order in Annexure G,
they said they have not vacated.
they said they have not vacated.
Yes.
How further clarify, my lord?
How that inquiry has been conducted by the executive?
Evidence was done, cross-examination was done. A portion of the cross-examination statements is in Annexure. It is recorded in the order sheet, page number 81 of the petition.
Affidavit contained that he will hand it over the vacant possession within 6 months' time in view of that memo, RFS. When that RSA has been disposed of?
My lord, RSA has been disposed of. On 30th of April 2014, well.
April
2014.
14. 6 months means?
They fixed the date, my lord. From 1/5/2014, 6 months, which comes about
1/5/2014
in the R Tingalu.
1/5/2014, he has to be vacated.
He had to be vacated.
Yes. Where is your affidavit? What is says? Number court, by order dated has directed me to file an affidavit stating that when I have vacated that scheduled premises, scheduled properties, as on 1/4 date on which that IA has passed in court. That compliance with the said direction, I state that I have vacated that entire suit scheduled property, part of that.
This is nothing but a conditional affidavit.
I am not in the possession of the said property as on so and so. That to be best my knowledge, ability, information, my family, I have are in the possession of the property adjacent to the degree suit scheduled property. Now you have to
Memo.
file an affidavit saying that on 1/5/2014, you have vacated that suit scheduled property. This is not that you have filed an affidavit with different colors.
No, Your Honor, I not only just this affidavit, I have filed the memo even before the trial court in 2014 itself saying that I have vacated
No,
this.
very simple affidavit we said, because you have undertaken before this court, and on the other hand, court itself has directed that you have to be vacated on 1/5/2014. If you are vacated on 1/5/2014, it is end of the matter. Otherwise, it amounts to a contempt.
My memo, my lord. I have filed some pictures. The first picture is of the initial position. There you can see house and Mane Mundero Vatara. That is the initial position. The third image is the present position, where you can see he has constructed a house. Adr hinde iro property ಖಾಲಿ ಮಾಡಿದ್ದಾರೆ. ಫ್ರಂಟ್ ಅಲ್ಲಿ ಪೂರ್ತಿ ಆಕ್ಸೆಸ್ ಕ್ಲೋಸ್ ಮಾಡಿದ್ದಾರೆ.
ಇದ್ರಲ್ಲಿ ಯಾವುದು ಪ್ರಾಪರ್ಟಿ ಇದ್ರಲ್ಲಿ ಏನು ಗೊತ್ತೇ
The property is facing the road. First page ಅಲ್ಲಿ
you come to that third page.
Please, my lord.
ಅದೇನ ರೆಡಿಮೇಡ್ ಗಾರ್ಮೆಂಟ್ಸ್ ಇದೆಯಲ್ಲ ಅದ?
ಹಾ ಅದೇ my lord.
That is not the suit scheduled property. That is what the that is what I'm saying to this court, Your Honor. The suit, this is the property that I'm in possession of. This was brought to the notice of this court on the last date of hearing itself. I want to take the court's attention to the suit.
Which is that suit scheduled property?
My lord, if I may clarify, kindly come to page number 83 of the petition, my lord.
No, again, the question, as per the question that let's get to the suit scheduled property itself, Your Honor.
Yes.
The suit schedule property, the schedule is at page number 52.
Yes. Which page, mister? Red color or blue?
Uh, my apologies, it's, I think it's blue,
Blue
page number
50.
51.
Blue is that
No,
order.
in the decree, it can be seen at 56, Your Honor. Decree schedule property.
Yes.
Okay, this is VP Kata number 1011, measuring 25 feet into 15 feet. This is the house, a small house. Along with this, there was a vacant site of 10 feet into 20 feet. This is the suit schedule property. It is as it is in the decree as well. And surrounding this, surrounding the house as well as the vacant site, there was a compound wall that was constructed. It is
Yes, yes.
the
yes.
compound wall still exists, though in a dilapidated condition. I handed over the possession of the property even before, as per the RSA.
No, this compound wall after that vacant place, that was the suit schedule property.
No, this photograph that is provided here is not the compound.
Yes.
The compound, if I'm not wrong, I'm not sure that I can, whether I can verify it or
Is
not.
that suit schedule property, mister, according to you?
The suit schedule property. In this photograph, I cannot show, Your Honor.
You produce that, which is that suit schedule property?
I can produce that. It is part of the record, but as of now, it is not before this court.
that
It
suit
is
schedule
already
property
marked.
Record. This, in the first picture,
Yes,
the house,
yes,
and you can see a person sitting there.
yes.
That is the suit. Both of these together are the suit schedule property.
That
Mane,
house-
mane mundero, whatever.
Hmm.
That is the suit schedule property. Now coming to the garments ಅಂತ ಇರೋ image photo.
Yes.
This ಇದ್ರ ಹಿಂದಗಡೆ ಖಾಲಿ ಮಾಡಿದ್ದಾರೆ.
ಎಷ್ಟನೇದು?
This portion.
Yes.
ಇದ್ರ ಹಿಂದಗಡೆ ಖಾಲಿ ಮಾಡಿದ್ದಾರೆ.
Yes.
ಮುಂದಗಡೆ ಖಾಲಿ ಮಾಡಿ ಮುಂದಗಡೆ ಹಾಗೆ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. To this fact, my lord, kindly come page number 83 of their petition.
ಮುಂದಗಡೆ ಖಾಲಿ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ವೇಕೆಂಟ್ ಪ್ಲೇಸ್ ಬಿಟ್ಟು ಆ ಮನೇಲಿ ಇದ್ದಾರೆ ಅಂತ
ಆ
ನೀವು.
ಮನೇಲಿ ಇದ್ದಾರೆ. ಮುಂದಗಡೆ ಖಾಲಿ ಮಾಡ್ಲಿಲ್ಲ, ಎದುರುಗಡೆ ರೋಡ್ ಅಟ್ಯಾಚ್ ಇರೋ ಜಾಗ ಖಾಲಿ ಮಾಡ್ಲಿಲ್ಲ. ಹಿಂದಗಡೆ ಮನೆ ಏನಿತ್ತು
ಅದನ್ನ ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದನ್ನ ಬಿಟ್ಟಿದ್ದಾರೆ. To this fact, my lord, kindly come to page number 83, my lord. 83 of their petition.
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಏನಿದೆ ಅದು?
Schedule ಅಲ್ಲಿ,
Clarify ಆಗಿದೆ.
Your Honor.
83, page number 83.
This is being,
wait.
yes.
Yes.
Page number 83, second para. ಕೋಲಾರ ರಸ್ತೆಯ ಪಶ್ಚಿಮಕ್ಕೆ ಖಾಲಿ ಜಾಗ, ಅದಾದ ನಂತರ ಡಿಗ್ರಿ ಹೋಲ್ಡರ್ ಅವರ ಮನೆ ಇರುತ್ತದೆ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಕೋಲಾರ ರಸ್ತೆಯ ಪಶ್ಚಿಮಕ್ಕೆ ನನ್ನ ಮನೆ ಇರುತ್ತದೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. ನೀಪಿ 9ರಲ್ಲಿರುವ ಚೆಕ್ಕುಬಂದಿಯಲ್ಲಿರುವ ತೋರಿಸಿರುವ 10/20 ವಿಸ್ತೀರ್ಣದಲ್ಲಿ ನಾನು ಮನೆಯನ್ನು ಕಟ್ಟಿಕೊಂಡಿರುತ್ತೇನೆ ಎಂದರೆ ಸರಿ.
ಅವ್ರದ್ದು ಯಾವ್ದು ಮನೆ ಅಂತ ಅವ್ರು ಹೇಳೋದು?
ಇದೇ ಮನೆ ಸರ್. 10/20 ಏನಿತ್ತು ಎದುರುಗಡೆ, ಅದ್ರಲ್ಲಿ ನಾನು ಮನೆ ಕಟ್ಕೊಂಡಿರ್ತೀನಿ ಅಂದ್ರೆ ಸರಿ ಅಂತಾರೆ. Based on this inquiry, an order was passed. And even, my lord, I am giving you the order of the latest order of the trial court, where the bailiff has filed a report stating that ಆ scheduled property ಅಲ್ಲಿ ಮನೆ ಇರುತ್ತೆ. This is the certified copy, my lord.
No, now that what he is did is that vacant position he has built up and he is.
He is built up and he is staying there.
Where is your title deed in respect of that property, Mr.?
Your Honor, there is a revenue document that is, this is panchayat property.
Yes.
And this is brought to the notice of the trial court also, and it is not, I'm not claiming that it is my own property. Through panchayat only, I'm in possession of the property. The revenue,
Documents, where is that license for construction of that property?
yes, I have all produced. It's all before the trial court. I can, it is marked also in the evidence. I can produce it on the next date of hearing, all the documents.
Monday.
Obliged, Your Honor, Monday.
Produce. Monday. Let him produce, yes.
Interim order may be extended.
My
Your
lord,
Honor.
Trimada.
they have submitted that the possession has not been, they are not in possession. Arrest may be stayed, my lord.
That's
They
what-
should not have problem in delivering the possession. There is a delivery warrant.
When the delivery, it
Arrest
is,
may be stayed.
File affidavit this court whether is vacated interim. What is that?
The order, my lord, is in 3 portions. First portion is the delivery warrant.
Get the comply with that copy, stay that person is ಕೊಡಿ.
It's at page number 30, the order is
30.
30.
Issue arrest warrant. Yes.
Arrest warrant may be stayed.
Yes.
Because there to delivery warrant and other thing it may be proceeded.
Order granted by this court on 20th to 2025 is modified. The stay of the impugned order only in respect of issuing an issue of arrest warrant against JDR.
Please, my lord.
Please this matter on Tuesday. Yes.
Serial number 38, witness Sriraj Gowda for petitioner. Pradeep
Appearing for the respondent in this matter, my lord. My kind apologies, my lord. I was unable to appear physically. I'm not keeping in good health. My lord, your lordships
time.
directed the petitioners to implead all the defendants in this matter. It
No,
seems
you
they
are
have not
appearing for
filed the
the
application. Respondent, my lord.
Respondent,
Yes, my lord, respondent.
petitioner. Yes, you want time. Yes. None appear for the
Petitioner
petitioner.
directed to
At the
file a
request
certain
of
application.
respondent, please. ಅವ್ರು ಯಾರು ಬಂದೇ ಇಲ್ಲ ಬಿಡಿ. Yes, this
ಬಂದಿಲ್ಲ.
matter of 2 weeks.
Serial number 39, Kevin Narasimhan for petitioner.
Respondent number
Pradeep
2 is awaited, man.
Yes, awaiting service of notice to R2. Yes,
Please interim order, my kind.
interim order granted earlier is extended till next date of hearing.
Serial number 40, Ravi Kumar NR for petitioner, connected matter, A Madhusudan Rao.
And for the petition, my lord,
For respondent number 1, ma'am.
this suit filed by the first respondent for the permanent injunction against the defendants, my lord. The defendant number 7 to 8 are the petitioners before this honorable court. And the defendant number 1 to 6 are the seller of the property to the defendant number 7 to 9,
Suit for,
permanent injunction.
you are the defendant.
For the defendant. my lord.
Yes.
The contested defendants, the petitioners, the contested defendants, and file the written statement before the trial court. And due to oversight and due to the instruction properly, they have not inserted now they sought for the amendment of the written statement.
What is that?
Written statement at annexure annexure D, my lord, page number 37. To add the para number 3A, there is a property, how the property has been flow to the plaintiff, that has been not stated in the written statement. That is why during the course of cross-examination, they came to know that the property, how the property has came to the position of the plaintiff. That is why without pleadings, my lord, the whatever the cross-examination.
What is the reason for rejection?
It is only for the delay after the sufficient time has taken. In the earlier occasion, they have not amended the written statement. That is the only reason the
Where is
trial
that?
court has. And the reason, my lord, in para number, page number 22, my lord. Further, it could be seen that the case at the trial court commenced when the case was posted for the further cross-examination DW1. At the belated stage, the defendant number 7 to 9 have filed the present application. On perusal of the affidavit, the defendant have not assigned the sufficient reason to delay in making the amendment of the application at the first instance.
No, that, what is that you want to be implemented, the amended?
Amendment, the property, how it is pro the title of the property, my lord, to the plaintiff. That is started in the kindly peruse the.
ನೀವ್ ಯಾಕ ಅವ್ರ ಸೂಟ್ ಅಲ್ಲಿ ನಿಮ್ದು ಟೈಟ್ಲ್ ಪ್ಲೈಂಟಿಫ್ ಎಲ್ಲಿಂದ ಬಂತಂತ ಅದು ಅವ್ರು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ ಅವ್ರದ್ದು ನಾವು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ, if I have not stated in the written statement, not taken the contention, we cannot take the matter because.
ಅಲ್ಲಿ ನೀವು ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಸೂಟ್ ಫಾರ್ ಇಂಜಂಕ್ಷನ್ ಅಲ್ಲಿ ಒಂದ್ ಲೈನ್ ಅಲ್ಲಿ ಡಿನೈ ಎವ್ರಿಥಿಂಗ್ ಅಂತ ಹಾಕಿದ್ರು ಸಾಕೆ.
We have
See,
denied.
ಅಲ್ಲಿ ನೀವೇನು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ. ದೇ ಹ್ಯಾವ್ ಟು ಪ್ರೂವ್ ದಟ್ ಎಸ್ ದೇ ಹ್ಯಾವ್ ಎನ್ ಎ ರೈಟ್ ಓವರ್ ದ ಪ್ರಾಪರ್ಟಿ, ದೇರ್ ಇಸ್ ಎನ್ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್. ನೀವ್ ಯಾರಿಗೆ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರಿ ಅವೆಲ್ಲ ಯಾಕೆ ಬೇಕು?
Now, it is not stated. The property.
What court said, it is irrelevant. This amendment will nowhere connected to the suit for deciding. Therefore, they have rejected. How it will prejudice to your right? Even this amendment is not allowed. It will not prejudice to your right because they have to prove how they have got this property, not you.
That is true, but only submission, my lord, without my pleadings, I cannot go for the submission and
No,
because without.
ಈ submission ಮಾಡದೇ ಇಲ್ದಿದ್ರು ಕೂಡ it will not affect your right.
ಅಲ್ಲ, ನನ್ನ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ನಾನು ಏನು ಆ ತರ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ, ಈಗ ದಿ ಪ್ರಾಪರ್ಟಿ, ಹೌ ದಿ ಪ್ರಾಪರ್ಟಿ ಒರಿಜಿನಲಿ ಬಿಲಾಂಗ್ಸ್ ಟು ಹೋಮ್ ಅಂಡ್ ಹೌ ದಿ ಪ್ರಾಪರ್ಟಿ ಅಕ್ವೈರ್ಡ್ ಬೈ ದಿ plaintiff, that if not stated in the written statement, I cannot argue the matter because if the
You are
succeeded
saying that
person,
how plaintiff has acquired the property or you acquire the property?
plaintiff acquired the property.
Correct.
Plaintiff acquired the property.
Or
Not
is the
our
property have been purchased by the plaintiff herein and other family? You are the defendant, no?
Yes, please. That is why the latest judgment of Supreme Court also held that.
Herein other formally belongs to so and so, so and so. Sold in property is that extent of 100 feet, so and so. You are admitting that she has, plaintiff has purchased this property.
Purchase the property, the extension is also different.
Hmm.
And it is not the what they claimed is, it is encroached by this defendants. This, what the defendants have the property is entirely different from the plaintiff, what the plaintiff has acquired the property. That is why the extent shown in the plaint schedule also.
It will affect
it is-
prejudicial
that is
rights.
why-
Let it.
That's
And,
admittedly, in the plaint, in the first paragraph itself, I have stated how I have acquired the property. my lord.
Hmm.
Copy of the sale deed is also produced.
Hmm.
The minute he has filed the written statement, he's well aware of the document that I have.
No, has he denied that?
He has denied my right in the written statement.
Adar explanation addition ಕೊಟ್ಟಿದ್ದಾರೆ.
It's the,
If he has not denied, then he has taken this contention, then it is nothing but he is
Lords, at
improving
one
this
hand,
case.
he has denied the right of the plaintiff.
Hmm.
The other hand, he admits that I have purchased the property.
No, he is saying that not the entire extent, some portions to prove that.
This has been filed after 9 years. Written statement was filed in 2015 itself, my lords.
No.
After a period of 9 years, after the cross-examination of PW1, an application is filed after the matter is posted for evidence of DW1. It
I
was not-
will not allow him to,
My lords, where is the due diligence, my lords? Because we have filed the plaint.
No,
In the
one
plaint
thing-
itself, the document is produced.
see, what is the stage now? His evidence is over.
Not yet, my lord.
Then
The defendant's evidence, my
I'm
lords.
relied on the judgment of Supreme Court, my lord, latest judgment.
evidence, see, evidence, if it is evidence is completed, we could have put in a condition that he should not recall that any witnesses for examination of this.
My evidence is completed, my.
Now he cannot-
PW1 is
see,
cross-examined.
He can only adduce his evidence. No witnesses can be recalled. We'll allow you to do it,
During-
subject to that, not to recall that any witnesses.
During the course of cross-examination of PW1 plaintiff,
No,
I came
you-
to know that how the property has been floated to the plaintiff. That is why.
You give your evidence,
Please, madam.
but don't recall evidence which is already over.
Please, madam.
We proceed further. That will-
PW1 may not